Thank you very much, Volker, for your kind and very detailed introduction, very generous, welcoming. It's a pleasure to be here to join this group of thinkers discussing various aspects of digital economy, digital society, and regulatory issues related to it. I will be talking today about the work in progress, essentially, from the regulatory perspective, the Digital Markets Act, and basically my purpose and my focus will be to try to articulate several not very commonly discussed elements of the DMA, and I'll have quite a specific normative perspective from which I will be addressing it. So I have those ideas in quite succinct slides. Let me share the screen. So obviously we are talking about shaping a new pro-competitive modality. We hear the phrase pro-competitive not only in academic circles or in political speeches. Now we have in the UK public consultation precisely on designing pro-competitive regime for the digital economy. So it's not a mere buzzword, but it implies that it has the meaning behind it, and the meaning is that the traditional modality of competition law, which is being designed to be responsive to the problem, to target wrongdoers, to penalize wrongdoers, and to remedy specific concrete situations, problems, or anti-competitive conduct or infringement of competition rules, has to be complemented for several reasons by the new modality, which is much more proactive and which is not interested that much in challenging wrongdoers or in penalizing wrongdoers. It is interested in designing the competitive process vibrant, dynamic, not exclusively oriented to the results, be it total welfare or consumer welfare, but perceiving competitive process within the digital market as a kind of, self-sufficient or thinking itself, so to say. And the starting point of this observation is that the Digital Markets Act offers a sui generis, or if it will be adopted as it appears to be, it offers a kind of sui generis perspective of competition law. It's more proactive than just traditional ex post competition rules, but it doesn't separate its intellectual pedigree from the rich and very sophisticated legacy of competition law, economics, and policy. It continues this tradition, but from the from a different point of view. And it's not a mere sector-specific regulation, because traditionally sector-specific regulation, as we know in the previous wave of regulatory initiatives to liberalize different markets, it somehow introduces additional obligations, but those obligations are very clear and concrete. And if you want to comply, you will know how to comply. With the DMA, it's a little bit more complicated, or perhaps more sophisticated from the juristic point of view. And from methodological perspective, it somehow manifests a decline of the law and economics perspective, or kind of caricaturized, simplistic, trivialized version of law and economics perspective, which somehow presumes that competition processes can be measured in all their totality, calculated, predicted, and the policy recommendations should be prescribed with a deterministic causality, which is kind of part and parcel of natural laws. Economic relationships are part of social rather than natural course of events, and of course and I blame lawyers here, because we have integrated this vision in very simplistic form. I think that's and now it's not a kind of a new start. The wisdom of law and economics will remain with us, but it will be complemented by the broader societal kind of interests, which are not necessarily commensurable to single metrics of calculus. Speaking of the DMA, I assume that the participants of our conversation today know the kind of the main elements of the DMA in terms of its purpose, the pedigree, and key characteristics. So I will start straight from the key specificities, which in my view characterize this proposal, the most nuanced, the most important issues of this proposal. And the starting one, I think it is the act which is designed to be opaque. I think the provisions of the DMA are vague and they are all-inclusive and they are full of adjectives. And we all understand that whenever you have in the text an adjective, fair, proportionate, reasonable, just, etc., then you open the door for interpretation. And so the presence of so many adjectives and so broadly designed situations is not a shortcoming of the DMA. I think it is its distinctive feature. It is opaque by design and for the right reasons. I also see it as a kind of future-proof regulation, and not only in this kind of traditional sense that we cannot catch up with the rapidly evolving digital reality, and thus we need the rules which somehow anticipate the development of the markets and allow a greater flexibility in terms of designing new obligations for the gatekeepers, which are not relevant today as we see them today. But it's also future-proof in the sense of its kind of participatory model, that there is and it's connected to the opacity by design, that the rules are so vague and the obligations are so all-inclusive that you kind of calibrate them, you create them for each specific gatekeeper. And unlike in the United Kingdom, where the new regime supposed to be bespoke, so tailored specifically these mandatory codes of conduct to specific, companies with strategic market status, the DMA is not designed, it's not supposed to be formally bespoke, but it looks that this future-proofness allows, and regulatory dialogue allows to talk about kind of quasi-bespokeness of the DMA as well. And finally, I think the last key feature is is contained in Article 6, and mainly in how we enforce Article 6. Because if you look at the provisions of Article 6, and the title of this article basically demonstrates that these rules are designed to be opaque, because the title of the article is Obligations Susceptible to being further specified. It's not that we didn't have time to craft, to design, to tailor a more precise set of obligations. They are designed to be susceptible to be further specified in the course of regulatory dialogue between the enforcer, who will be this enforcer, we don't know yet for sure, and each specific gatekeeper in each specific situation. And the trick, the main juristic novella of the enforcement of these obligations of Article 6 is that they can become binding from the moment when we reach a consensus, we as enforcers and gatekeepers, and each individual gatekeeper. And if we reach such a consensus, the provisions of Article 6 will become binding from the moment of the consensus, pretty much. Or it would be very difficult to imagine otherwise, though logistically not impossible. If we don't reach the consensus, the provisions of Article 6 will become liable from the moment when they will become binding from the moment when they have been envisaged to be binding. So the gatekeepers are nudged very gently and politely to reach a compromise, because it is in their interest to reach a compromise with the enforcers, because otherwise the whole totality of broad, all-inclusive and intentionally opaque provisions of Article 6 will become binding for them. All totalities as far as the relevant core platform service is concerned, of course. what is the reason for such opacity by design? Why do we need such new kind of juristic equilibristics? What is wrong? The main reason is obviously regulatory dialogue, and to mitigate perhaps the systemic failure or systemic challenge which the traditional ex-post competition enforcers often have when deal with biggest market players and in trying to apply competition law. Not only it's very long process, not only it is very context specific process, it is also very formalized procedurally process. And if the defendant is a big company, they can hire the best legal and economic and technical expert, data scientists, for example, teams who would be able to argue every comma, every letter in all these kind of wide provisions of primary and secondary law. They can problematize it, and often cases are lost not on the merit, or let's say less categorically, too much of the limited regulatory energy is spent to discuss casuistics, which is, nobody says that casuistic is not important, but it's not the most important thing in such vibrant and such societally important area. So by introducing the message of this intentionally opaque obligation is kind of, look, you will be liable. We will find a way to bring you liable, and don't try to discuss this. You will become liable if you want to, if you'll decide that you will be liable. But we don't want you to penalize for this kind of very broad catalog of obligations. What we want to reach a kind of a meaningful working by means of regulatory dialogue, working compromise with you about how you do your business online, because no legal rules are capable to offer a pragmatic and effective steering role for the function of the digital society. We don't understand how the algorithms work. We don't understand the whole totality of factors influencing all this kind of remarkable growth of big tech companies. How on earth we can anticipate that all obligations will be enforced? We try to reach a compromise. That's my observation about DMA. So basically, we have de facto a shift of burden of proof, saying you're liable, you will be liable unless we reach a compromise, unless you welcome the regulators and we sit and discuss the issues as they are, rather than as you try to demonstrate them to be. And again, metaphorically, I think it's quite, if the whole digital economy is being driven by the remarkable individualization, by this remarkable ability of matchers, be it social media or search engine or any other core platform service, to match the producers with consumers, the suppliers of the services with end users, advertisers with publishers, etc., etc. If this is kind of tailoring, kind of individualization is the core of the business model, regulators are metaphorically learning from this, and they try to design individualized rules for all biggest gatekeepers by introducing this asymmetry. So the asymmetry of the Digital Markets Act is not limited only by the addressees of these norms, because it is asymmetric. It applies categorically to a set of predefined companies which pass the quantitative thresholds, and it doesn't apply at all to all other companies, which creates a kind of situation where if you barely pass the threshold, you will be subject to very heavy, strong, and comprehensive obligations. And if you one step below this threshold, you will not be liable. The Digital Markets Act will not be applicable to you at all. And thus, there is some element of kind of not punitive, but some kind of attempts to tame, some attempt to regulate in a smart way, rather than just prohibit a conduct, because the conduct itself, we know that it's problematic. Usually all these obligations address very problematic issues, but if they are really objectively problematic, then it would be more suitable to design a format which we have in the Digital Services Act. Namely, we would have a pyramidal structure where, with the proportionate increase of obligations depending on the size of the intermediary. With the DMA, we don't have it. We somehow identify those who gatekeep the markets, those who prevent the markets from, or those who are kind of indispensable partners on our unavoidable trading partners de facto on one side, and all the rest of them, of the companies who are potentially competitors to the gatekeepers. So there are elements of kind of artificial kind of asymmetry by design in terms of defining the addressees. And the second asymmetry is the opaqueness and the interpretative, the endless room for interpretation in terms of Article 6, but also to a large extent Article 5. Now, coming to the normative question, we obviously want to ask ourselves, how can we understand, or we can rationalize, we can have a meaningful conversation about the DMA if we know what is its main purpose? Because fairness and contestability, it's kind of yes, but what is behind these terms? And clearly, we can cover all competition-related values because it has various different dimensions, but we need some priorities in terms of our kind of academic understanding. What is the purpose of them? Why are we designing such a powerful, such omnipotent carrot and stick without knowing what is the ultimate goal of it? So it's kind of, we need to know this answer to this question. And there could be several priorities. The most obvious is consumers, because the ethos of consumers, they are, by the way, are called users, not consumers in the DMA. It's always with us. And that would be probably the most, not naive, but how to say, the most shallow understanding of the DMA, because DMA is about market rather than about the end outcome. Ultimately, in the digital universe, consumers, should we care so much about consumers being, not receiving enough of digital content, or it's an important thing from economic point of view, but from kind of normative perspective, it's less important. The most obvious and most explicit dimension of the objectives of the DMA is clearly the intra-platform competition. And it's understandably, the platforms being so powerful, the gatekeepers and the services which they offer being so powerful, we have competition within these platforms, and this competition is very sophisticated. It's not that like we have competition as a two layers, inter-platform and intra-platform. Within the intra-platform competition, myriad of different competitive dynamics or interactions taking place. So I by no means underestimate the importance of the intra-platform competition. It is the part and parcel of the DMA. It's most obvious part, and it has to be here for the right reasons. The the potential side effect of this kind of focus on exclusively on the intra-platform competition is essentially that we cement the status quo. We basically say, okay, there is not much we can do about the current gatekeepers, so let us try, at least as society, to teach them how to conduct, how to behave politely, how to act, to do business correctly, how to offer their services in a transparent manner, how to avoid the most kind of drastic instances of self-preferencing, etc., etc. This acknowledges, it assigns to the gatekeepers a kind of quasi-status of public utility somehow, which is probably unavoidable, but I think it should not be. The intra-platform competition is not the only dimension of competition which is relevant in the DMA. Now, the next obvious question would be the inter-platform competition. And here we are entering to the core of my normative kind of conundrum. Because on one hand, inter-platform competition can exist and will exist with or without the DMA, because each of the gatekeeper it controls the core market which it originated at, and also it wants to enter into new markets. So we can have kind of ecosystem competition, competition between ecosystems. And if I wear my competition law, kind of traditional competition law shoes or hat, I would say that despite its kind of intuitive problem, it delivers many pro-competitive outcomes. You know, it can trigger, if 6 biggest companies will continue competing fiercely for entering into each other's market, it can deliver many positive outcomes for this kind of purely, neutral, law and economics, neoclassical, let's say, vision. But I think that the problem with ecosystem competition concerns not the outcomes which it can or cannot deliver, but the very structure. So it is more, my concern is more kind of order liberal, of order liberal flavor, but I go a little bit further than this, because I wouldn't say that the structure alone is a problem. I even dare to say that probably, if we look at the importance of the digital markets in the kind of current Internet of Everything society, in the age of the 4th industrial revolution, where data is kind of new energy and gatekeepers are kind of new infrastructure, if we take this kind of publicistic style for serious, then it looks that it is in the genuine interest of each sovereign, be it the European Union, its member state, or any other polity, to somehow think about helping domestic or kind of affiliated companies, at least to have a greater chance to try to compete. And this comes to the great problem with our traditional vision of competition law. Because for competition law, the greatest taboo, the greatest offense is to try to marry competition law with industrial policy. And it's changing now, but still this kind of the flavor is of negativity is there. So such concepts of as digital sovereignty, I think, they cannot be considered as part of competition, as a legitimate part of the goals of competition law, even sensu lato, even if we take competition law in its broader kind of proactive sui generis modality, even in such open-minded constellation of the goals of competition law, the objective of digital sovereignty is not a goal of competition law. It's not a legitimate goal of competition law. But it's not the end of the story, because by not being the goal, it remains to be an important external factor. And nowadays, when competition policy is getting less and less insulated, less and less inward-oriented, self-sufficient, and self-focused, with having the host of various competition and movements emerging as we speak, so to say, the interaction between competition policy and other external factors which volens-nolens influence competition policy is a legitimate question for competition policy academic discussions. How this interaction take place? Should we take the Strauss approach and just say because it has this pedigree of negativity and the flavor of kind of taboo of industrial policy, should we just ignore these questions? It's the easiest thing to do, of course, and many colleagues opt for this choice, and they are in many respects are correct. But there is equally legitimate reasons to be open to this kind of external influence. And I think if you look at the DMA, such external influence is present. So when we talk about inter-platform competition, we imply that we are not talking about inter-platform competition qua inter-ecosystem competition. And if I support purely law and economics approach, I would say, well, inter-ecosystem competition, it's not perfect, but it works. It can work, at least conceptually speaking. I don't see a problem with 8 or 10 different gatekeepers in their kind of domestic nurtured market trying to enter each other, they would create the competitive dynamics in all the traditional respects. But only from the perspective of of the position of normative position, which I try to articulate, not to advocate, but only to articulate. I think the inter-platform competition, qua the ability by using the driver of ordoliberal theory to allow a more friendly opportunity, but only an opportunity, because then we enter into very slippery slope of correlation between industrial policy and protectionism, and it comes in conflict with the foundational values of liberal democracy, which we can never encroach or compromise. So it is really a conundrumal situation. It's kind of the DMA is between Scylla and Charybda from this normative point of view. But the very fact that it is between Scylla and Charybda should make it even more important to discuss, rather than trying to somehow to distance ourselves from this dimension. So the next important question is, of course, okay, if it goes like this, then probably it doesn't comply with the processes which take place in the United States and China, whose authorities are also remarkably or showing remarkable signs of activism in the area of trying to somehow to introduce new modality of competition rules vis-a-vis the digital gatekeepers. They have different visions, but they go in the same direction. But unlike European counterparts, they have their own big tech. So somehow if they apply such kind of simplistic understanding of the DMA being driven by purely national, by the interest of digital sovereignty, it would probably not explain the complexity of the trend, because the trend is not limited only to the relationship between a specific specific trendsetter jurisdiction, let's say, and the rest of the world who compete on the global scale in this kind of global digital race for trying to be this infrastructure provider for the future kind of internet of everything. It obviously concerns the relationship between public power and corporate power. Yeah, that's kind of dimension which is much less relevant for competition law, but somehow it is driven by what Luigi Zingales very eloquently explains by saying that you don't have to show your political ambitions in order to create this existential problem for the governments. The very fact that you are able to create this, to apply this political damage, that you are able to transfer your expertise from the economic field to the field of politics to change the outcomes of elections with one metaphorical click in refining your algorithms or newsfeed. This very fact alone implies that big tech companies create somehow discomfort even for those in which jurisdictions they function. So this could probably explain partially, only partially, and only probably superficially, the reason why we see this dynamic. But also probably the main reason is because we want competitive process. So it's not only about industrial policy. I think industrial policy or digital sovereignty argument is a minor argument. I think so that it exists. Now, a few words about this kind of binary pyramidal structure and about the relationship between the Digital Markets Act and the Digital Services Act. My main concern with the Digital Markets Act and its kind of twin sister or twin brother is that we are so preoccupied and so busy with our intradisciplinary or intra-niche development. So much is going on in each of our niches that we are barely able to understand the problems as they exist and as are being discussed in our neighboring areas of regulatory expertise, and even more so if they use the same terminology as we do. So it's kind of they use them as synonyms or even as homonyms. They use the same term, but they mean different things in different kind of regulatory silos, so to say. And I'm afraid, or my concern is that it's not impossible that the DSA and the DMA, by using the same terminology and by being driven by the same general objective or broad objectives are being, they're designed for different purposes. Obviously, yeah, the DSA is kind of tries to develop more mature and more responsible, more sustained e-commerce kind of area, and DMA tries to trigger competition. But what is most important, what underexplored, is the unintended consequences. If, and I'm asking if, the DSA can create something, in addition to all the positive effects which the DSA will create for the competition, if it can create something negative. And the main example which concerns me is the requirement for transparency. The DSA, as you know, if you read it, will require all intermediaries, depending on the size, this requirement will be either softer or stronger, but all intermediaries, but micro and small, will be required to disclose different types of information, which is now is commercially sensitive information. And obviously, such a disclosure will create huge opportunities for markets to flourish. This is undeniable. And we will have, many, new startups and, the new wave of innovation in these markets, because so much information will be available, and thus so many new algorithms could be trained, etc., etc. However, I still think that this kind of privacy paradox, which we all know, that whatever you design, you can somehow end up with this kind of, or rather King's Midas paradox. Whatever big tech touches, it turns it into gold. It is not unlikely to imagine a scenario that such transparency, and remember, this transparency of the DSA concerns not reports to the public authorities or some regulators, but to make it publicly available in publicly available reports. So if such avalanche of data will become available once over sudden on the market, on one hand, there is kind of a clear opportunity for startups to create new added value, new products, and trigger new dynamics of competition. On the other hand, there is even greater possibility for the current gatekeepers to cement their status quo by exploiting the information which the potential newcomers, the potential challengers to the status quo will have to disclose before they reach the level comparable to what allows us to think about them as gatekeepers. So, in other words, there is a risk that becoming a company of a comparable size to gatekeeper under such strong transparency rules is much more difficult than it was for the gatekeepers themselves to become as powerful as they are now. And there are many objective explanations and reasons for this. And I don't dare to deny any of those reasons. That's why, for me, this is kind of a conundrum. It's kind of dilemmatic relationship, because we have to pursue these reasons. We have to try to develop them and to promote them. But these consequences is not only unintended, but it looks that it's also unavoidable. And I hope I'm wrong, and I try to infer too much from this disclosure. But it looks to me that one of the consequences of this would be that the greater difficulty for the potential newcomers to challenge the entrenched status of the current gatekeepers. And this leads me probably to the last point about the designating the gatekeepers, because I think it shows remarkable kind of legal sophistication. And the original draft proposed by the Commission, and the further improvements or amendments to the original proposal as offered by different European Parliament committees in terms of reports and opinions, they show that that these nuances are really important. But what is really important, I think, here is the third quantitative requirement concerning or granting the potential challengers 3-year period to scale up and to mature. I think it demonstrates indirectly that there is kind of the idea of the DMA is not exclusively focused on the intra-platform competition, because this 3-year gap basically can be explained only by the intention to welcome newcomers, and they will be somehow of the size, even if they reach the size comparable to the current gatekeepers. For 3 years, they will not be subject to the obligations of the DMA. And in the digital life, we understand that 3 years is quite a long period of time. And obviously, we can discuss the relationship between the European Commission and its intention to have an exclusive position to enforcing the DMA on one hand, and the position of the 27 national competition authorities, who show remarkable unanimity in trying to encourage the legislators to adopt more, let's say, synchronic approach rather than exclusive approach. If you're right, we can discuss this during the DSA. Perhaps the last point, which I think is important, is that I think that it's really important for the Commission to keep either the most of the competences in its hands, because actually the DMA, this kind of designation of the gatekeepers and in particular the fine-tuning of the specific objectives of Article 6 in particular, requires surgical precision. It's really context dependent, and we should, when we discuss the division of labor and competence between the Commission and national competition authorities, we should try to avoid the situation, at least, that this will be designated to national competition authorities. Because what is really important for the Commission is to say which obligations will be enforced, but also to somehow say to the gatekeeper in the course of this individual regulatory dialogue, which obligations will not be enforced now somehow. And if we open this mechanism to the national competition authorities, we can have the situation which was similar to with the situation of leniency, where we somehow grant immunity against public enforcement, but then private actors can sue the infringer, and this destroys, this undermines the very idea of somehow of whistleblowing. So I hope that by calibrating the specific relationship between division of competence between the Commission and national competition authorities, these nuanced, delicate factors will be also taken into consideration, and not only the desire to share the expertise and to help the Commission with its very limited 60, I think, or 80 people, to help the Commission with the much broader, much more robust set of members of staff available in many EU national competition authorities. Thank you very much for the opportunity to speak, and I'm happy to discuss this with you in the format of Q&A.